Rahul and Think India team for bringing such terrific opportunities for our Indian students, be it in the form of panel discussions or internships with the UN or the members of parliament or senior councils. You guys are doing a great job, so kudos for that. Secondly, may I just say how honored and how excited I am to share this stage with Harish Iyer. He was one of the petitioners in the 377 matter, me and my senior, Mr. Mahesh Jethmalani, represented him before the Constitution bench. But more than a client, he is my hero. He's been a savior to many members of the LGBTQ community, giving them strength and hope every day and day in and day out. So Harish, thank you for being who you are. This world is a better place because of people like you. Now coming to the subject matter of this discussion, which is decriminalization of homosexuality, many questions unanswered. So I will come to the many questions unanswered part shortly, but I will first take us through what 377 judgment was all about. Now section 377 of the I.P.C. is about the unnatural offenses. It states that whoever has carnal intercourse against the order of nature, whether with a man, woman, or an animal, is liable to be punished with life imprisonment or imprisonment up to 10 years and fine. Now the strongest argument in favor of 377 as it was understood prior to the 377 judgment by the Constitution bench was that how can 377 be in violation of Article 14 of the Indian Constitution when it clearly states that even the sexual activities between a man and a woman, which is against the order of the nature, will be punishable. So clearly, it was meant to regulate a particular sexual act and not a particular section of people, i.e. homosexuals, bisexuals, transsexuals, and so on. I believe the first biggest jolt to this argument came about when the Indian Penal Code was amended in 2013. Now this amendment came about after the Nirbhaya case, wherein section 375 of the I.P.C. was given an expansive, gave an expansive definition to the term rape. So prior to the amendment, section 375 defined rape as sexual intercourse between a man and a woman against the will and without the consent of the woman. Post the amendment, it expanded this term rape to include any kind of sexual activity between a man and a woman, whether coital, non-coital, procreative, non-creative, oral, anal, every kind of sexual activity would constitute a rape if it is done without the will of the woman and without the consent of the woman, which meant that if the woman gave consent to any kind of sexual activity, it would not constitute an offense, which means that 377, after the 2013 amendment, was left to only target the sexual minorities of this country. So when the 377 judgment came about, if you read Justice Deepak Mishra's part of the judgment, it declared Suresh Kaushal versus Nas Foundation as being per incurium, meaning the judgment was passed without giving due regard to an existing statute. It is so because this amendment came about in February 2013, whereas Suresh Kaushal versus Nas Foundation, that judgment was passed by the Supreme Court in December 2013. So for 8 months, the law had excluded any kind of consensual sexual activity, whether or not against the order of nature within the meaning of section 377, as to not constitute an offense if it was consensual. And that is precisely the reason it was also in violation of Article 14. Because when you have permitted heterosexual adults to indulge in any kind of sexual activity with consent, then singling out just one particular community of our society amounts to violation of Article 14. Then the second biggest jolt to this pro-377 argument came with the judgment in Justice Puttaswamy's case of right to privacy. That judgment spoke about, that judgment basically said that sexual orientation was a very important facet of right to privacy. And right to privacy was a very important aspect, was an integral part of Article 21. Thereby it was constitutionally protected right. And this particular ethos of Justice Puttaswamy's judgment is reflected in Justice Chandrachud's judgment of 377. He questioned the mere definition of order of nature. In his judgment of 377, he states, what is order of nature? Who decides what is order of nature? Who decides what is natural and who decides what is unnatural? And can we really allow the state to dictate these watertight definitions of sexual preferences and sexual orientation? No. What this judgment did was that it told that the state had no business in one's bedroom, as long as the activity behind that closed door of a bedroom is between consenting adults and there has been no grievous hurt. Now, if you just look at this legal reasoning, it's not a new concept in our legal jurisprudence. Our Indian Penal Code is not just a book wherein sections have been haphazardly printed. There's a logic even to the sequence in which the sections have been assigned, its numbering. To begin, let's start with section 87 of the Indian Penal Code. What does section 87 say? Section 87 I.P.C says that as long as an act does not amount to grievous hurt or death, if it is done by the consent of both parties, provided they are adults and legally capacitated to give consent, if in the process of that act, either of the parties are hurt, the other person is not legally liable, or his action would not amount to an offense. Now, if you just read the illustration in that Indian Penal Code, just after section 87, the understanding would be much clearer. It says that A and B consent, they agree to play fencing. And during the process of fencing, A gets hurt by B. Now in this case, the action of B does not amount to an offense. Why? Because A consented to fencing and he was aware of the risks involved. As long as that act did not amount to grievous hurt or death, that act, which in the absence of consent would amount to an offense, ceases to be an offense in the presence of consent. Now, this particular reasoning is also reflected in the sexual offenses section of our Indian Penal Code. Starting from 354A, unwelcome overtures, 354B, sexual assault, 354C, and 354D, which is stalking. Also 375 and 376. So yeah, 354C is voyeurism. Now these are all sexual activities which constitute an offense merely because there is no consent from the woman. Therefore, singling out 377 and saying that consent is irrelevant in this offense was not a sound legal reasoning, which Justice Chandrachud, Justice Deepak Mishra and Justice Nariman very clearly elaborated in their judgment. And now coming to the part of what next. I believe 377 was the necessary move. It was long overdue. And everybody in this country, I think most of the people in this country are extremely happy that this decision came about. But what the decision has done is it has merely decriminalized a particular section of the society. It has not given them any civil rights. There's no right to marriage, no right to adoption for the sexual minorities in our country. But also because they could not do it. That was beyond the scope of the petition. The petition was limited to the constitutional validity of Section 377. For the civil rights to come about, the three main organs of our state, the judiciary, the executives, and the legislature, will have to work in tandem to make it happen. And my biggest hope is the Special Marriages Act. Forget the personal laws, like the Muslim Law Board or the Hindu Marriage Act or the Christian Law Board or Parsi Law Board. Just take Special Marriages Act. Why I stress on Special Marriages Act is because it defines marriage between any two persons. It does not use the term man and a woman. Also, it only prohibits marriage if the two people are related to each other, are immediate relatives, by blood or by adoption. So that is, I think, the strongest tool and our biggest hope right now. So I would like to conclude by saying that I hope we elect such leaders who care even for the sexual minorities of our country. I hope the people of this country have the courage to stand for what is right. And I hope it doesn't take another 65 years or 67 years for us to recognize those rights for the sexual minorities of our country. I'll pass on the mic to Harish now. Thank you.